Okay, great. Good morning, everyone. I'm going to call the Eastham Zoning Task Force meeting to order. This meeting will be video recorded and broadcast over local access channel 8 and through the town website at www.eastham-ma.gov. Welcome, everyone. We have everyone's received an agenda, and we're going to get right to our beginnings with Carolyn Murray. Did we get minutes distributed? Did Pat distribute minutes?
I didn't see it.
No, we had no minutes. Okay. Then you didn't get anything, did you?
No.
No, okay. So we'll defer the minutes of our last meeting till next meeting. Make a note here. Okay, great. So, remember the vote? So as we've discussed, as we've gone through a variety of our issues, there were certain legal questions that we wanted to sort of get some clarity on before we dug any further. So we do have Carolyn Murray with us today. And Paul and I went over a few questions, but we can open this up. This is a great time to open it up. So Paul, do you want to take a lead here?
Sure. Do you want to do anything in particular first, or just follow the agenda?
You need to open the meeting with the statement, Karen.
I just did.
Oh, you did? Oh, okay.
Did I just read this? I did read the statement.
We can all say, no, you didn't. Just to get it.
And I would doubt myself enough to go, okay, I'll read it a second time. Okay. Open the meeting with,
No, do you want to follow the agenda, or do you want to jump to something particular first?
no, I thought we were just going to. I thought we were
Zoning
gonna,
admin?
yeah, well, no, it's zoning admin, but there is a series of other questions we have for Carolyn.
Yeah, that's what I'm asking.
Oh, yes,
What-
yes,
which-
we'll start with that.
Okay, the zoning?
Carolyn.
I
Carolyn,
know, it's all related to Carolyn, that's why.
okay, well, I don't care, we can go through whatever, however they did, we can do it, whatever.
All right. Hi, Carolyn, how are you? Can you hear us all right?
Good morning, everybody.
You're a little confused today.
The
okay?
zoning,
The coffee hasn't taken hold yet.
That's
Uh,
okay. That's okay. I figured I would also just let you folks know, Abby Sklar from my office is also listening in because she did a little bit of research on zoning administrators. So I invited her to sit in to hear the discussion.
all right, great, welcome, Abby, thank you.
Welcome, Abby. We were wondering, like every once in a while, we get a member of the public here. It's a very unusual occurrence. And so when we see a foreign name, it's like, oh, someone's here. All right, well, why don't we start off with the administrative position? And then there were some other issues around seasonal communities and things. We can go on from there. Okay.
So where this started was, for a while, I've kind of felt we need extra help, staff-wise, staff capacity with the zoning enforcement. And obviously, given the last few years, we've passed a lot of new zoning bylaws. The enforcement has always been an issue just with staff capacity. So this really came out of examining what can we do, at least within the existing staffing we have. State statute allows towns to create a zoning administrator position. And there's certain parameters around that. And so that was kind of where we're examining, is that a model we want to try to use? Is it, and that's just where, Carolyn and Abby can help us kind of guide through, like, is that kind of one size fits all? Are there options we could do? Can we have some sort of hybrid? And so where the hybrid item comes to my mind was the research that Jackie did that we sent out to you, was some towns have this zoning administrative position. Some towns seem to have zoning enforcement officers, and I should back up a second. That's basically, in general, unless there's someone else appointed to the position, the building commissioner is the zoning enforcement officer kind of by default. And so that's what we have in Eastham, but obviously there's a capacity issue with the time and level of effort that's needed to do that. So that's where we kind of ended up where we are now examining. So there's a zoning administrator with certain roles and responsibilities and duties. Can we do appointment of zoning enforcement officers, or maybe what that might entail? And then I think an important piece of all this is, what is the role of the boards, particularly the ZBA, and all of this, if we were to have some sort of other appointment, other staffing? So I kind of, you know, everyone has the research that we sent out, and I kind of really just wanted to walk through and have Carolyn and Abby kind of walk through from their experience, what they've seen in other towns, what the pros and cons are. But from my viewpoint, I think we do need the ability to have other staff empowered, appointed, whatever it is, to at least help with the zoning enforcement at some level. So again, talk through that. Is there anything I'm forgetting that I should mention, Jackie?
No, I don't think so. I think it will be helpful to draw a distinction between zoning administrator and zoning enforcement
Yeah, that's
in the conversation, and ask for KP's team's help on that.
So I think that's kind of where we are, and obviously, as there are all questions or details, we can get into it. So I guess Carolyn and Abby, if you wouldn't mind, just kind of maybe from your standpoint, what your work with other towns, what is the most common? And if you have, you know, the pros and cons, that would be helpful to start.
Sure. So good morning, everybody. Happy Tuesday. And hopefully by the caffeine will kick in for everybody momentarily. So as you were starting, both you and Jackie, or I think we're starting to describe, there's a zoning administrator, which is recognized by Chapter 40A, and then there's this zoning enforcement officer. The zoning enforcement officer is probably, in my experience, the more prevalent position that exists from town to town. And as Paul was saying, it's usually your building inspector or your building commissioner who's charged with being your zoning enforcement officer. And that can have some successes and some frustrations. And without necessarily getting into, you know, personalities that may hold the position of building inspector or building commissioner, by training, those folks are versed in the enforcement of the building code. And while we think that building and zoning are certainly intertwined, in my experience, zoning enforcement or zoning interpretation can sometimes be a challenge for building inspectors, because they might certainly understand that this use is allowed in this district, or this use is only allowed by a special permit, or you need a variance to put the building that close to a lot line or something like that. But, you know, there are some nuances, particularly with things such as, you know, pre-existing non-conforming uses, or sometimes like the application of the Dover Amendment, that those are things that, unless a building inspector or a building commissioner has had some prior experience with that type of a situation before, those tend to be the areas where they need a little more support. Let's put it that way. And then there's just the enforcement aspect of things. That, again, building inspectors are typically accustomed to acting on permit applications, reviewing plans, going out doing inspections to make sure everything is in compliance. And then when someone comes along and says, you know, my next door neighbor has too many unregistered vehicles parked in their driveway, or I think they're running a business out of their residential property, those types of things sometimes slide down on the priority list for building inspectors and commissioners, just because there are other things that are more pressing, or that require that they act within a certain amount of time. So I don't see as many zoning administrators, or I don't see as many separate positions for zoning enforcement officers. I know that in the materials provided, I think there were 4 towns that you had identified as having some separate zoning enforcement officer. I can think of a few other towns that do use a traditional zoning administrator, and maybe we should just stop there for a moment, because the distinction, as Paul started to introduce, is under the Zoning Act, under Chapter 40A, Section 13 recognizes the position of a zoning administrator. And that person is not necessarily someone who is just dealing with zoning enforcement, but that position could actually also issue permits and do some preliminary reviews based on whatever authority is either delegated to them by the zoning board or by a bylaw. So, for example, in a couple of communities that have a zoning administrator, they have typically have a bylaw in place that says something to the effect of, no one can change a use of property or apply for any type of permit without first getting a zoning determination. And that zoning determination would really just look at what is the zoning that applies to this zoning district, what is the use that is proposed, is the use allowed? If the use is allowed, but only with, say, a variance or only with a special permit, then the zoning administrator kind of gives you that initial overview of the zoning analysis of things that you might, the zoning relief that might be required to do what you want to do. Then there's often a separate building inspector. And the building inspector is the person that, after you've gotten all of your zoning approvals from the zoning board or the planning board, or even the Conservation Commission, once you get all of your approvals, then you come back with your construction quality plans, and off to the building department you go to get your building permit. So there's sort of, there are two aspects that work very much in tandem with each other, but often building inspectors wear both hats. And, depending upon what your experience is, I guess, in your town, maybe it works well, maybe it doesn't work well. Now, what I understand you folks are considering is actually just a zoning enforcement officer. And maybe after this conversation, maybe you go in a slightly different direction about that. But the bylaw can designate anyone to be a zoning enforcement officer. So right now, it is your building inspector. You could broaden it to your building inspector or designee, or the building inspector, or specifically identify some other folks, such as from the planning department, which is what I understand you're considering. You could do that. Multiple people could wear the hat of zoning enforcement officer. What I think this board needs to consider is, are we just looking for additional people to help with zoning enforcement? Or are we really looking for, state law, Chapter 40A zoning administrator that would have some broader authority? If you are just looking at someone to help with the zoning enforcement matters, then you do have to consider things such as, do you just, typically right now, if somebody got a zoning opinion or a denial of zoning enforcement, say from your building inspector, if anyone was aggrieved by that decision, they could simply appeal to the Zoning Board of Appeals. The proposal that's been prepared so far would designate some folks from the planning board staff as zoning enforcement officers, and that decision would be subject to review by the building inspector, and then the building inspector's determination would ultimately be appealed to the zoning board. I'm not suggesting you can't do some sort of structure like that. I think we just got to think through a couple of things in terms of making that clear in the bylaw that that is the process. If we're going to deviate from that process such that anyone aggrieved by any decision of a zoning enforcement officer can go straight to the Zoning Board of Appeals, then I think we need to build that into the bylaw. If you are going to have a situation where the zoning enforcement officers provide a recommendation or a determination to the building inspector, who ultimately can say, I agree or I disagree. What does that look like when you disagree? If it's going to just clearly be that the building inspector's determination is final and the only one that can be appealed to the zoning board of appeals, that's fine. Consider then how the zoning board of appeals or the public might feel if they have a determination by a zoning enforcement officer that says, yes, you can do it under these conditions, and then a building inspector who says, no, this is not allowed. Now you appeal to the ZBA. Is the ZBA going to hear both sides of that and kind of arbitrate the dispute? If I were the member of the public who sought the zoning enforcement and got an ultimate determination that I didn't agree with, I'd be waving around the other determination, that was overturned and saying, but wait, ignore your building inspector. Listen to what Jackie wrote. Her analysis is so much better, for example. It just things that not insurmountable, just things we need to kind of think through the mechanics of it so that the zoning board knows what they're supposed to do with it. But as I said, I think you could take either avenue. It's just a matter of deciding whether you'd want to just start with additional zoning enforcement officers or whether you do want to think about the full-blown statutory zoning administrator who could actually issue some permits depending upon what the bylaw provides. So I'll pause there because I did a lot of talking there. So
Thank you. Could I just add, so just building off what Carolyn was saying, that scenario that she just described where we kind of have competing staff, I personally I don't want that to be the situation we get into. So for my 2 cents, I would say let's stay away from that model.
Yes.
The experience that I've had here in Eastham is that just the way things go, the building commissioner has always been the zoning enforcement officer, the bylaw, but the way things go, it's just my position has always been the one that's closer to, even before we had this group. My position, I was writing the bylaws, I was working with this group of the planning board, I was in that realm. I'm closer to the bylaw and I was writing them or helping to write them, and I understand the building commissioner is wearing 2 hats. As Carolyn said, enforcement was always a lower priority. And in the past, and you can get into personalities and interpretations, and it's like, well, I wrote the bylaw and I think it's this way, but I don't have the enforcement authority, so I can, we've had spirited discussions, but at the end of the day, it's like, it's a different person that's doing it. And even to the extent of trying to help the commissioners and past commissioners kind of shoulder the load of doing that, I can be the in-between person. I can say, here's what the spirit of it was, the intent. I can deal directly with the person who's having the issue or the people complaining. I can write the letter, I can do everything, but at the end of the day, I can't sign that letter and I don't have the enforcement capacity. So I can do everything else under the sun to try to help it, so that to me has been a difficult situation. Because just from practice, I'm doing all the work, but at the end of the day, I can't sign a letter and I can't follow up on it. And I'm still relying on someone else getting to it when they get to it, that kind of thing. So that's been that dynamic. I will say our brand new building commissioner, Basil, he was gonna join us. He got called away to go to high school or something. If he gets back in time, he's gonna sit on this, but he's brand new. He comes from the building trades piece, the zoning piece in general is new to him, and obviously with a new town in general, but in a new town. So again, we're kind of in this thing where Jackie and I are closer to the bylaw. We're trying to help him learn the bylaw. He, to his credit, he's fully on board with doing enforcement, and we've already started to do some things. So just from a structure working piece, I think we're all on the same page. We don't want to shy away from doing the enforcement, but it still comes down to what's the best model, what's the capacity for the staff, and just like you said, it's the nuts and bolts of like, how do we actually do enforcement in a systematized way with smooth function and not getting in each other's way and duplicating efforts. So that's really where. Sorry, one thing, it's an important piece. Distinguishing between the enforcement officer and the admin. In our bylaw already, there are areas in the ECSD with minor site plan review. There's areas with that we just put in with the vegetation bylaws where we're already referring to planning board, zoning board designees where they are made, basically comes down to me, Jack, where we would be empowered to make certain approvals, not special permit approvals, but minor site plan admin approvals. So I guess I wanted to remind everyone that we kind of have like half a toe in that doorway in certain areas of the bylaw where to me, it kind of goes down to the zoning administrative thing. So again, just keep that in mind as we decide what's the best model. And I also want to make sure we don't lose this thread of when we figure out what path we want to go down. I also want to talk through like what is a procedure and a policy for the zoning enforcement piece. I think it'd be good to get everyone's view on that because our policy has been, at the end of the day, we want compliance. We don't want to start penalizing people and issuing citations and all this stuff. At the end of the day, if we can work people to get to compliance and have some patience and have some, that's always our preferred method, but that takes time and that can lead to frustrations and delays. So that has its own issues. But I think talking through ultimately, like, I would like to have a game plan, like we issue a letter, we issue a follow 2 letters, 3 letters, whatever it is, then if we feel we have to issue a fine, like who issues that fine? Do they first go to a board and have a hearing? And then it's through the direction of a board that they direct the staff to issue fines, or is it all at the staff level? So those are some other things to keep in mind that I'd like to talk through because I would like to come out of this with here's the model and then here's some procedures that go with it.
I just want to take us back a minute, Carolyn. In terms of these 2 choices, an enforcement officer or administrator, what is the legal process to put these in place? I mean, are they both bylaw changes? Is one a general bylaw, one is, just help me understand the path we would have to go down to get approval for either one of these.
No, good question, Mary. They would both be bylaw changes. And I would recommend that they actually be zoning bylaw changes because typically, right now, the zoning bylaw will designate the building inspector, for example, as the zoning enforcement officer. If you decide you want to add additional zoning enforcement officers, we might just look at amending that provision of the zoning bylaw. Same thing for a zoning administrator. That position can just be done by a bylaw change. And again, it should be a zoning bylaw change. If you really, and just to throw a wrench into things, if you really want to do something crazy, and I'm not suggesting you do, but if you wanted to do something that was just a little bit outside the ordinary in some way too, like for example, I think somewhere in the materials here, I saw, that the designated zoning enforcement officer would have the authority to issue building permits or conduct building inspections. And I flagged that. I'm like, oh, no. That's got to be, a certified building official. But if that was something that you were interested in, we might even need special legislation to really make that happen. Because if we're going outside of, a zoning enforcement officer is perfectly fine by a zoning bylaw to designate as many people as you want. A zoning administrator to review or even act on certain permits under a bylaw, that's fine as well. But if we're going to go a little bit beyond that, and it doesn't sound like you are, but if you were, I'd say we might even have to explore special legislation. But so far, I think everything could be done by a zoning bylaw change.
Why don't we get Carolyn and then Mark?
I just want to pause for a second. Sorry. Come on in, Basil. Have a seat. This is Basil Congrove, is our new building commissioner.
Yay. Hi, Basil.
Hi, Basil. Nice to meet you.
Carolyn, do you have a question?
Well, I guess, yes. And let me see if I can figure out how to ask the question. We're talking about sort of three different titles and functions, the building commissioner, the zoning administrator, zoning enforcement, right? And they conceivably could all be the same staff person.
Well,
No,
that's,
well, right now they are.
Yeah.
Right now Basil's does all three jobs, right? With assistance from you guys doing the talking with people about zoning and specific stuff that aren't building stuff, right? So when we go to set up the bylaw, we're setting up functions and the responsibilities of those entities, the people that are going to carry out those functions. But we're not necessarily naming, we don't necessarily have to name the specific person,
no, we don't, no,
right?
But
We're not in the bylaw, you know, we don't even have to say town planner, right? Do we have, how do we?
Right.
Right, I mean, we just say that there's a zoning enforcement officer
you allow the
And-
town to report.
and whoever is the appropriate, either
Yeah.
the zoning board or the select board.
Yep.
Appoints who that
Yep.
is, right? Okay. Because it conceivably. From time to time, based on skill sets, on staffing, on volume of work. Once we have the statute, the bylaw in place. Then the zoning board and the select board, town administrator. Can make those appointments and change those appointments as need be, right? So I think we shouldn't think of this as. Jackie and Paul and Basil. I think we should think of it as, these are three functions that we need to have done. And we want to have them done well in our town. And. Let's be sure we have all three functions laid out and how they relate to each other.
Mhm.
And then we worry about and talk about who's gonna do the function.
I think in the proposition though, and that was very helpful, Carolyn. I think the administrative versus enforcement would not be two positions, but would be either or. We would have to make I think the decision before us today is to evaluate. Because, you wouldn't have an enforcement officer, well, I guess you could theoretically have an enforcement officer and administrator, but that's usually not, it's one or the other.
Well, if we do the zoning administrator position, like Carolyn said, that has. The capacity for that position can issue
Permits.
certain permits, and this can all be,
Right.
controlled down to.
Yeah.
The broadest, like,
What type of permit?
What type of
And that was the point I was going to make, because outside of this particular discussion, we're talking about permits for fences, for sheds,
Sheds,
for campers and other types of trailers.
tree removal.
All those things that are gonna be way down the stack for Basil, I imagine. So is that the type of thing that we wanna have staff handle? And if so, does that automatically mean we have to go to administrative versus enforcement? Can an enforcement officer do any approvals of permits? I think I heard that, no.
no. But so
Wait, I don't think I heard that same answer.
yeah,
I was, sorry, the
Carol,
question was to Carolyn, all right.
enforcement officers can't issue permits.
Correct.
Okay,
Right.
A zoning administrator under chapter 40A can issue certain permits, yes. But a zoning enforcement officer is really limited to enforcing the bylaw, when folks come in and say somebody cut down more trees than they're supposed to, or whatever it may be.
Thank you.
so I would like to hear maybe from Paul's perspective, because to pick up what Martin said, we've been talking about, and we've made changes in the zoning code, and we're talking about others now that are much more, sort of, they're not
dependent on the state building code.
They're not dependent on the state building code, the fences, the landscaping, all of these things. And we're sort of reacting to this because the blowback we're getting is we've put 20 zoning codes on the books.
Yeah.
And half of them aren't getting, this is directed to you. There's no enforcement, and we've got a situation where neighbors have to file formal complaints against their neighbors to make things happen. So, but the other part, and you started this, is this whole notion of, even in the DCPC, we required folks to come to you before they come to the planning board. So we sort of, and we did that because we were saying things like, people would get so far, they would get, spend $100,000 on architectural drawings and get before the planning board. And the planning board might not have liked the process, but then you get into the heartache of, well, I've spent all this money, you're gonna deny me. So we kept making changes so that we wouldn't get to the planning board just being with a gun to their head of someone who spent too much money, that people are getting informed up front. And we spoke about last week about whether someone wanted to take their front fence from, potentially 4 feet to 6 feet in the front. Is that an administrative review with the landscaping as opposed to Basil doing enforcement? So I think there's a continuation of this. So my inclination feels like, given everything we're doing in the zoning code, now granted with definition, because I wouldn't be open for the administrator to start really doing your board job. But what's your reaction to this as you've seen the two positions delineated and how it works in your office?
Well, obviously, there's gotta be a bright line between anything related to the building code and everything else, so, but my feeling is we need capacity in both areas. I don't think one person can't handle all the zoning enforcement, and because in enforcement, like I said earlier, it takes time. It's talking to people, like writing a letter, giving them time. So it's unrealistic for one person, whoever it is, to do it, in my opinion, to do
Oh,
it.
yeah, I think we're all on board that we want to expand. I thought the question is there anything that the administrator or the enforcement officer can do that the administrator not can't? Isn't it just a subset of one? Isn't the administrator also an enforcement officer?
My understanding.
It could,
That
It could be.
Yes,
Okay, so what we're saying is that we want the enforcement officer, which is what your ask is. But we also see the ability to issue simple permits would be just another benefit.
Yeah.
Basil, I think I'm happy to hear, Basil's here, the feedback from in
And like I said, we already have that in certain areas of bylaw already, like minor site plan.
the
approval,
DCPC.
In the DCPC and with the perimeter vegetation. We talk about, it's a planning board designee, but to me, this would actually,
But you run into an issue now where you're like, you need one person to approve your fence and another person to approve the plantings in front of the fence.
well, that would all.
Be bundled together.
Yeah. Right now, in the perimeter bylaw, it talks about the planning board's designee, basically me, can approve this situation unless we notify butters, unless someone complains and they want a full hearing with the planning board, I basically approve it. So that would be bundled with, if we get into fencing regs and landscaping, all that stuff. That would just,
Throughout the town or just restricted to DPCP?
the perimeter bylaw is throughout.
Oh, no, I meant in general. So when we get to camper permits to put a camper in any house, or whether you want to put an 8-foot fence on the side of the house, when we do need a permit for some of these things, or, one of a shed, for example.
Well, the shed thing is definitely a building code thing. You need a building permit for a shed. Or what happens is
Yeah.
someone wants to build a shed, they need to pull a building permit. They need to show us a site plan showing where it's going so that we can make sure there's no zoning issues, setback issues, or if it's over 200 square feet, is it a site coverage issue?
So would you expect that to go to the zoning enforcement officer first to review that and then tell Basil, we reviewed this one, it looks good, or would you just let Basil handle it?
Well, I think the advantage of having the zoning administrator is that you have the most capacity. At least that's starting with a blank slate, that position has the most capacity to do enforcement, to play a role in issuing permits, or even if it's not issuing permits, do a pre-review work, assisting the building commissioner. So I guess that gives us the most options. And then it's from there, it's like, how do we tailor that down into what is appropriate for Eastham and what we need and what is going to work with the building commissioner's role and needs. So I guess give the big answers. I think the zoning admin is preferable. Again, we already have bits of this alluding to it in the bylaw. It would actually kind of help formalize it. We haven't really had an issue where, I think I've issued maybe 2 minor site plan approvals in ECSD over the last, I don't know how long we've had it, 5 years. and they were really minor, you know, it's like nothing. So we haven't really had a good test of all this stuff, but it's also, in my mind, it's still a little goosey with how that happens. It's really almost too informal. So again, this might be help us get some.
Right. It's up to you, mental plans for the people that replace us.
Right,
You
and
know,
it's
we all
not,
understand and
I'm
work well together, but that's not 5 years from
Well, okay.
now.
I'm a little leery of staff level decisions also, just because unless we have a really good procedure where people understand, applicant understands what it is, and then there's a role, like what happens if you don't like the decision. We never really built out that. It's kind of
Right.
like, come to me, I issue a letter, we're not, you know, there's no, so I look at this as an opportunity to kind of build out like a better procedure that everyone knows what the rules are, what the parameters are, what we can and can't do. And then what do you do from there if you don't like the decision? What do you do? What do the boards do? What's their role?
And we would differentiate, to your point, Paul, hypothetically, if we recommended an administrator and there was a bylaw for administrator, it would be followed then by probably procedures that your team would bring to the planning board and the ZBA then for approval. I mean, would that be one would be to get the authority, two would then be develop the policies, procedures, and get those planning board to,
Well, we would need to amend the bylaw, as Carol
Yeah.
said, to create the position. I would think, defer to Carolyn or others, that we would put some language while we're doing this as a bundle, put the language about the roles, responsibilities, parameters into the bylaw, so that it's all.
okay.
Right, and if I could-
Would you be tying your hands then? Because in the future, if you wanted to tweak something, then you've got to go back to the entire process with town meeting. As opposed to put some of the rules in.
It's like
place.
design guidelines.
Right, oh, yes.
Exactly, but leave some of the rules that, you know, so if you see a hole, you can just go back to the planning and zoning, whichever way you decide.
No, you're right, that you run into that issue. That's exactly why we wouldn't want to necessarily put specific positions in the bylaw, because then you gotta, you know, you
Right,
put
right.
town planner every time someone.
Like the bylaw
Keep
should cover things like the appeal process, right? If someone doesn't like your decision, they can go to Basil. If they don't like Basil's decision, they come to CBA. And then they go to court.
Well, I think he's trying to avoid being in a situation that Paul and Basil are in the chain of competing recommendations, meaning if Paul just has purview over a set of things,
Well, somebody,
somebody has. I mean,
Well, first of all, the document we have is all about the zoning enforcement officer. So I think we're shifting now to saying maybe we want an administrator instead.
Yes,
Well, before we jump too much, though,
Sorry.
quick question. If I'm reading it right, in the background paper, it's in section 40. Under that listing anyway, it says that the administrator gets appointed by the ZBA. Is that true? And if so, does that take it out of the planning department? To some extent, and out of your purview?
So, right, so that is how state law is written. If we wanted to have, say, the zoning enforcement officer appointed by the town manager or something like that, we could certainly discuss that. But right now, if we were just going to adopt the model, if you will, that the state gives us, it would be somebody appointed by the zoning board of appeals. I don't necessarily think that a zoning administrator appointed by the ZBA then has no authority with respect to the planning board. But I could see a situation where, there are sometimes conflicts between the two boards. In terms of, I think Paul was saying it even better than I can at this point, is that, this task force in particular has been researching and drafting and proposing zoning amendments for the last several town meetings. And then everything gets vetted through the planning board. And then town meeting adopts it and off we go. And someone comes in and seeks a permit for something. And now they're going to the building inspector and or possibly even a zoning administrator who maybe didn't see how the sausage was made to truly understand the intent behind the bylaw or what it was or was not supposed to apply to. And now this other person comes in with a fresh set of eyes and interpret something very differently. So it could be such a situation, but, I think if who appoints the zoning administrator is your concern or sticking point, I think we could come up with an alternate model for that.
Does that require a change in state law though? Or could we do that through the bylaw?
I think depending upon what you decide to come up with, it would likely require a special act of legislation to do that.
Yeah, I think we need to think carefully before crossing that bridge, because I think,
Yeah.
Paul, your statement about having the ability within the planning department, since you're you're the expert behind all this, and your department is the expert behind all these laws, that just creates another dichotomy here that we're moving the problem area from one area to another if we put this under the ZBA.
I just wanted to,
But
please feel free to,
Why don't we hear
uh,
from Dave?
put it on the spot, but Dave certainly.
I think it was the 48 outline that, I just read it quickly. So the zoning administrator would be selected by not selected, but approved by the ZBA, and then secondly approved by the board of selectmen. So.
Oh,
both of them.
Okay,
Oh, so
That's-
there's
that's
a
state law.
check. There's a
So
check.
there's a check on that, yeah.
Okay,
yeah, but
And
that makes it
we can limit their scope as well.
that kind of makes it, to me, feels like an assistant to the ZBA, right? It's helping them with special permits, it's helping the ZBA with some of their work as opposed to doing the enforcement that we're
I
trying to
think
get.
you're right. I mean, I think that's the model, and I think you see these more in larger towns and cities where it's like, you're really only going to the ZBA as your last resort.
Mm.
Right.
As you're appealing, and that's what the appeal is, you're appealing. And that's really what it is, even with the building. So you're appealing because I can't get a building permit, I can't get a zoning, I have to appeal that decision. And then you make a case to the zoning board, well, what's the special attention you need, what's the variance? I think in Eastham, we have the model where it's, you just go to the zoning board, it's like by default, and that's your starting point. I mean, it's rare that you don't get a building permit issue, that, it's usually doesn't happen. It's very rare that you're appealing the non-issuance of a building permit. So it's really like the stuff we handle is the bread and butter is just setback issues, site coverage issues. You already know, you set the bylaw, you just by default, you're going to the CBA. So you're actually not like appealing anything yet. You're going for permission. And that's where it gets a little confusing when you go into enforcement, because when you go into the state statute about enforcement, it's really set up, again, I'll defer to Carolyn on the nuances of this, but it's really set up because, again, you're appealing this. I can't get this approval from the commissioner or from a zoning admin staff. Or my neighbor's doing something. You're supposed to, there's a whole sequence of you put something in writing, it goes to the building commissioner or whoever the appointment, they have 14 days to figure out what they're gonna do with it, and then if they don't. They decide I'm not enforcing this, or I don't agree that this is a zoning issue, then you're appealing, then you're going to ZBA, because you're appealing the non-enforcement or the decision that it's not a legitimate issue to the. So that's where the enforcement piece, to be honest, gets bogged down to, because and in the past, this, you got a neighbor complaining about a neighbor. You drive by, yeah, I actually agree, this is a zoning issue, but I need something in writing, or do I act on it? I agree, now it's in front of my eyes, I can't ignore it, or, I could ignore it, but should I? No. Does whoever is the appropriate person take action, start that enforcement? Or do I say, I need something in writing, which that, some people don't want to do that. Then I don't have anything to write, it's just, so that's part of this procedure piece I alluded to, like. That's really the way we've operated for the whole time here is like, you got a zoning issue, send us a letter, request zoning enforcement. It's just,
it's reactive.
it's reactive, but it's also sets up the issue where if it's a low priority or we don't, it's reactive. I guess that's the piece that I've run into many times in the past is that I agree. I've seen this. I think it's a zoning issue and we should enforce. Now it's in front of our eyes. We should enforce it. The person, the neighbor has called up and brought this to our attention and we agree it's an issue, but do we then still need them to give us a letter to initiate this whole thing and go through a whole process? Or it's like, okay, it's right in front of me. It's clearly a zoning violation. How do we go about it?
So as the enforcement officer, you take the burden off of that neighbor or that butter to have to write a formal complaint. You will see it, you can say, I can proceed from there.
Yeah, I mean, part of that has been a capacity issue in the past. You know, again, responding to every last thing. It's a full-time job, it could be, so, so there's always variables. I agree it's an issue, but I don't have time to deal with it because I got, 100 building permits, I got emergencies going on, whatever it is, or I agree with you, but I don't want to deal with it, so write a letter, I'm not gonna do anything, and then you go to the zoning board. That has been a model in the past where it's like, I'm not gonna deal with this. But you should go to the zoning board, then the onus is on the person making the complaint.
Right.
And this is the other part, not to get too far down the rabbit hole, but it goes into. The burden is then on the person making the complaint. They have to go to the zoning board, they're filling out forms, applications, paying fees, getting before a board,
Actually, legal representation.
right, for an issue. Where staff actually agrees there is a problem, so that just
Yeah.
leads to a lot of frustration on that part.
Yeah.
So that's why I'd like to clarify all this stuff and have a roadmap to. These things, so maybe it's an expedited in that case, and that will happen, there will be cases where the staff and the person making the complaint aren't going to agree, but at least maybe we have a streamlined way where, maybe we don't have a fee, it's a simplified appeal to the zoning board, and, it just gets into a lot of nuance, and you're complaining about a property that you don't own the property. And the person, so the ZBA doesn't have permission to even go on this property unless the owner, you get into all these things, so how are we gonna assess this? The person getting complained about could say, I don't, not paying attention to any of this, no one has my approval to go on the property, it just gets into all this subtle kind of awkwardness, so.
But we're starting to run late. I don't want to lose Carolyn and everyone, but Basil would love to hear from you, your perspective.
Okay, I've been here only a short period of time. And the biggest, I don't want to use the word hurdle, but what I've seen in the past, and maybe this is why this is even an issue now, is in the past, before I was here, there's been inconsistency in enforcement and interpretation and all those different things. What I would bring to you as my professional opinion would be the request for a little bit of time to be in a position to create that consistency. One of the first things I did when I was here, I devised a formal complaint form. People come in, they have an issue with a sign or a neighbor, whatever, they fill out the complaint. With a new program we have with OpenGov, we can now log that in, it tracks with the property, and if it's a health complaint, zoning, conservation, or building, it'll trickle out to those areas. Then I have 14 days. Up until now, and I would anticipate going forward, Paul has been a very good resource for me because from my understanding, a lot of those zoning bylaws have been crafted by him. So the questions I have, or he and Jackie have been a very good resource. And then I feel in the few instances we've had, I've been consistent with either the time frame or the action and the follow-up. Now, looking into the future, what's happening is things are changing in different areas in the law. That's changing my responsibilities as short-term rentals and things like that. And the building department, in one way or another, is going to have to expand. As that happens, and I bring on a local inspector and more of an admin into the building department section, what we have now, that will allow me to spend more time doing the, looking down from 10,000 feet and being on top of the zoning and things like that. Getting back to the OpenGov program, there are different specificities in there as these things come up through the planning board where they require certain plantings and things like that, there's a drop down in there where we can send out somebody like Jackie. She can actually inspect with something that's not in, 780 CMR. So something me or a local inspector would have to inspect, but it's still something the town wants to make sure that is in compliance. So I think with the tools that we have now, I would just request a little bit of time before you made any decision, just to allow me to attempt to bring the consistency that we may not have had here before. And that might be, a little hubris on my part saying, oh, this is before I got here, it was this, and I'm the sheriff. But my point is,
Yeah.
I'm hearing it for so many different areas that I'm comfortable stating that I can guarantee I will be more consistent than what we've had.
And I think Basil, the question that came, I think you're correct. I think we perceive that there's been inconsistent application. However, I think there's a larger question that we keep racking our brains about, which is capacity. That there's a real capacity issue. And that when I think about the percentage of our homes, like 75% are over 70 years old, there is a remodeling wave that just naturally is going to happen over the next 10 years. These houses are falling apart. The demands on you to do basic building and, enforcement, code enforcement is huge. And so I'm just trying to understand, because I think we talked about not going back to a particular person, like structurally, are there going to be things that really are never going to be your priority given capacity and demands? Like your basic job, I think, is going to have so much more demands in the future, but
What I heard from Basil, and correct me if I'm wrong, is that you view that the capacity issue is there, but I think what you're saying is that sometime in the future, you think you'll want this support underneath it. So is it just a question of, yes, we do want enforcement or admin, but, I view it as maybe immediately it's in the building department. And then as we get more of these roles and get an actual full-time position dedicated to this sometime in the future, that position then rolls under you. Like, is that essentially how you're saying it?
I'm not quite there yet. I'm sorry.
Mark, there.
Martin, I'm not there yet. The point I'm trying to make is I'm so new here.
Yeah.
I don't know what I don't know.
Right.
So I'm just asking for a little bit of time to let me figure all this out. Paul brought this up to me last week and said, hey, come on. And I tried to do a little bit of research, but still. And I had an opportunity to talk to some of my peers to get their spin on things to see what's done in other towns. Because in starting different programs that we don't have in place, I'm just looking out to see who's doing this currently really well and take some of the best practices from there.
Mhm.
So that's where I'm at right now.
Anybody?
What?
Did you find anybody? Any towns?
Unfortunately, it's like drinking from fireworks. So that's my purview at this point. I'm not really saying this is the way to go or that's the way to go. I'm just saying, if you give me an opportunity to continue to be consistent, and we'll see what happens with the staffing and things like that. So I don't really have the experience in this town at this point to really give you an opinion one way or the other.
I don't want this to sound like I'm putting real pressure on you with the idea that you want some time here, but there's another dynamic is that whatever we decide here with this committee, there's an involved process that really hits the bricks in January for a May town meeting, that if we have to make changes to the bylaws, it wouldn't be approved until May, and then the Attorney General may have to weigh in on it, depending on what we do. If the process of getting comfortable with it before you can make recommendations is going to take too long, again, I'm not trying to beat on you here. It could be a whole nother year if we miss that cycle. So I'm just throwing that out there for something for us to consider. Because obviously this is going to weigh heavily on you one way or another, could make your job a heck of a lot easier Or you're gonna say, why did I say yes to this? And it could go either way, and I understand you need the time to figure that out. But we have currently people who have issues, and that's why we're discussing it now. I would hate to miss the cycle, so it wouldn't be until May of 27.
Yeah.
That
Just
would
to
be
give
approved.
Basil an idea, this would typically go to the board of selectmen sometime in February.
We usually write our report, release at the end of January. Last year, like around February 6th, we presented to the select board
Or-
preliminarily.
Yeah.
Then we'd go to the planning board, depending upon what it is. Last year,
But
go ahead.
what I'm getting at is so from Basil's point of giving additional input, any of the meetings that we have between now and January. But you will also have the opportunity to write your own memo to the board of selectmen saying, here's how I agree or disagree. And whether they approve it or change the reporting structure or the appeal process. All that has room to happen in January timeframe, just to.
Well, it doesn't get voted on to go on the warrant till usually the third week in March.
Right.
Yeah.
And with the planning board has a hearing, and we've made a lot of changes between report writing and warrant. That's just how it's gone. I would be interested,
Just to be
go,
fair,
Carol,
I'll come back to the point I said before and then add one of what we talked about, Paul. I think what we're trying to talk about is the three types of functions. The building commissioner, or that relates to the building code, the administrator for zoning that relates to the zoning code, that's not the building code, and then the enforcement activities. And I think we just need to, I think what we would want to do is be sure that the bylaw that we put in place addresses those capacity functions, not who's doing them. How they get appointed would be addressed in the bylaw. So we could say there are those three functions, and all three are, after the bylaw is adopted, all three are appointed and are the building commissioner, or the building commissioner's designee, or they're the building commissioner and the town planner. However however that ends up being done. But I think what we're trying to do is be sure that the select board and the town recognize that we view that there's more of a function that needs to be done than currently we have baked into the town.
Right.
And wait a minute, let me finish. And then the second part of that is, that's all at the 25,000 foot level. This is the overall strategy of how we're going to do it. The nuts and bolts of how it's actually going to work, who's going to write what letters on what day, who's going to use what document to do that. Exactly how that's going to work in terms of if a butter, comes and brings something to our attention, who's going to look at fences and trees and sheds, and that all gets put into the policy and procedure. That is not in the bylaw. That's a separate document that ultimately Paul and Basil would work on together to come up with and then present to the planning board, the ZBA, the town manager. That all would be, it may be being done simultaneously with the assumption the bylaw would be approved, but they're two different things. We don't want to get too down into the weeds of the details as we think about the bylaw. We know that all has to be done, but that's not our job to do. And that will change from time to time, with staff changes and capacity issues and so forth, and experience.
Mm-hmm.
So I think our group needs to be still thinking at the 25,000 foot level of what are the things that need to be done and need to be baked in, and the purpose behind that. We're trying to be sure that the zoning gets decided, that we build according to the state building code, and that all of that gets enforced. And we want to make it as easy as possible for the people who live in the town to know what the rules are, how to play by the rules, and what to do when they feel like the rules aren't being played by. I mean, that's sort of our purpose. And that's what goes into the bylaw. So, yeah, so I think we don't need to overthink it at this point too much, because that's gonna come later.
Martin, did you have something?
So I was in agreement with Carolyn, is that that's the process here is to put a tool in place and how the tool is used.
Strategy.
And whether the tool comes out of the box later on is sort of up between Paul and Basil.
Yeah.
But at least the tool would be in place to create either an administrator or an enforcement officer.
And you get the flexibility.
And you have the flexibility.
Flexibility, you build in the flexibility.
Right.
I mean, Paul, I'm wondering, based on hearing the legal comments and hearing this discussion today, you know, so much of this is internally how it's gonna work in your department, you know? I mean, we don't have to be at procedures, but even at the 25,000 foot level, you need to think about organizationally based on your experience and Basil and all of that, how this is gonna work. So could we leave this, that the nuance here, since we know the parameters of the decision tree here? Could you come back to us with a recommendation in a month or, you know, however, whatever time? I mean, I feel like so much of it, I think we're sort of at a top level in agreement that we need we need the flexibility of a function. But exactly what it's called and how the appointment and the procedures need to really be fleshed out.
We can do that. I think in fairness to Basil, I agree with what he said, you know, this has been an issue that predates Basil's
Oh, yeah.
arrival. And as I said before you got here, as I was saying, you've already been attacking the zoning enforcement very well, so, but I just think it comes down to the tools, looking beyond, like, what is the coming workload, what are the responsibilities of all these positions, and just, we want to have a tool in place, whether we even use the tool, that's the other thing, whether the tool is there, whether we need to use it now or in the future, but it's there. But I think this is all stemming from a lack of consistency that goes back many, many, many years. And so the fact that just the timing. You're brand new, you're already addressing issues, so we're on the right track already. Certain. But
And I would just ask Basil to think about this over the next, you know, several weeks as you're building this out. I mean, what you're saying about your tools and all of that is great to have. I think the sentiment that we've been hearing and the sentiment that came out of the select board is not just being more efficient, which we need to do about responding to those complaints, but how are we proactively enforcing zoning? I mean, we're all seeing clear cutting all across the town. You know, do we have a system, do we have capacity within the building department that we're not relying on somebody to complain in order to have a level of enforcement? I mean, some stuff is really obvious, we all drive around, but that's sort of at the capacity level, like not just ticking off, I've hit my complaints, but you know, and there's communication too. I mean, the other part of this where I think about administration is, I've said to the select board, we've passed these 20 zoning codes. We haven't done a lot of public communication once they got passed. So not only to owners, but to landscapers, to contractors, to architects, they're not even fully aware of some of this stuff. So some of the compliance issues could go away with communication potentially. But I also think it's not just the complaints coming in. How do we be more proactive about this? I just ask you to think
So
about.
if I hear
Yeah.
what you're saying correctly, some type of public awareness
Well, there's public awareness.
after these zoning new regulations are enacted, or even current things like some type of outreach
Yep.
or something like that, as well as reacting instead of waiting for the complaint. Is that
Yeah.
what I'm hearing from you?
That's part of it.
That's part of it.
So, because Paul had mentioned reactionary earlier.
Yeah. Well, I mean, we are in a
No,
reactionary.
that's what I was.
We're in the and you're building a system to take in all the complaints, which absolutely that system needs to be built. But there's another leg to the stool, and I just wanted you to factor that in
No,
to the
I
capacity. issue.
understand what you're
Yeah.
saying. I'm just trying to wrap my head around of, you know, how that actually happens Monday to Friday.
Yep,
Right.
no, I know.
Processing, yeah.
And that's part of what we're cognizant of is there's the functions and what needs to be done, but there's also just sheer staff capacity to do all of that work. And we're kind of advocating that we understand there's a capacity issue and that needs to be addressed.
Well, at
in
the
the
same
staffing
time,
plans.
I can understand there are certain priorities also.
And
Our philosophy, as I said, has been, our approach has been that at the end of the day, we want compliance. And so I would rather issuing citations and fines is like the last resort, because nobody likes that, and that is a huge burden on staff and going to court. And so it's always, these things take time, because if it's the approach of like having some patience, working with them, yes, they need doing some letters and follow, but that's a capacity issue. So it's a process issue. But the pre-enforcement, the education, that's a big piece of it in my mind also, because it's being able to demonstrate that we're doing enforcement and administrating it uniformly, not just picking on people, because that's always a potential reaction. They're picking on me, everyone else has got, and the sign code is gonna be, everybody's got signs up, why are you picking on me? Well, we got the complaint about you, so now we're forced, that's the reality of it, doesn't mean it's fair or whatever, but do general education. Here's the new bylaws, it applies to everybody, please be aware, you do a spring, summer season, everyone's got their signs out that here's what the bylaw is, then at least you've demonstrated we've made everyone aware of it, we've given you ample time to talk to us if you have questions, you don't understand it. Then when we get into the complaints, we can say, we're not just picking on you, everybody was, because that's part of it too. And then you always have to spend time refuting that stuff and dealing with it and saying, but the last thing anyone wants to do from their side of the desk is go to court or anything. And I'm sure Carolyn will attest that they don't want, the last thing they're gonna deal with at court is sign violating. They got criminals there doing stuff, they don't want that stuff clogging up the works with tree violation or a sign violation. And, so that it all goes down to the more we can be efficient in that system in-house. It helps everybody.
as part of your research, I think Carolyn said, how it works mechanically and approvals, I don't have opinion, I really want to hear from you. It strikes me that if you had an administrator, you've now gotten a bylaw that gives you broader authority, and you could always craft it to be more narrow. You may not use the broad authority. It's sort of like if you're gonna go to town meeting, there's a little inclination on my part to get the broader authority and then craft it to be smaller. And maybe the question of whether that's the right choice might be when you do your research. I think Carolyn mentioned there's 4 or 5 towns that have this administrator. It'd be great if you could, you have no time, but if you could get on the phone and talk.
Reporting structure, that'd be a good question.
What is the reporting structure? How do you deal with conflicts? I mean, it's more the internal mechanisms of towns that do this. Do they say that this is the worst idea we ever did, or it's great? Or we had these 3 problems and then we had to fix them this way?
Yeah,
That
I
would
think
be-
we got the research Jackie
Yeah.
did, go back and follow up with top.
Just-
I've talked to a few
Few,
here and
yeah.
there, I've got some feedback for that. So, yeah.
Okay,
Come back and follow up, it'll give me available time to think it through also. So
okay.
So basically what we're talking about is the potential to take these 2 functions which are defined and disconnect it from the building commissioner and make it an appointment by the select board. Right, I mean, is that what we're talking
Well, it
about?
sounds like the law is an appointment by the ZBA, but it has to be confirmed by
Well,
the select
but that's the
administrator.
position, and the enforcement position is currently wired to the commissioner. My only thought is, I think we need some consistency, whatever we create here. And we talked about consistency, and that's important. I'd hate to see it kind of swing in the wind, depending on what the select board currently thinks in any particular year. And it seems like it's nice to have it in one of the 2 departments. That's my opinion.
Okay.
Whichever way you think is appropriate.
Okay. Carolyn, do we still have some of your time to talk about a couple other legal questions?
You absolutely do.
Yay.
Okay, thank you. No, you don't have to stay. You can stay, but you can stay. We good? We can, well, we have Carolyn. Did you, I know we talked about some legal questions. One of my biggest questions, and I read the seasonal communities brief last night. And I also read, where is it? Do you have the site of that? I'm trying to get my head around issues of tenure, of our ability to mandate year-round ownership or year-round occupancy, Carolyn. And this comes up with,
Yep.
it came up with hotel motel, it comes up with everything, inclusionary zoning, it comes up with ADUs, it comes up with all the time. So my question is, the Cape Cod Commission did a year-round occupancy incentive bylaw. But on the first page, they talk about a Massachusetts Supreme Court decision that limits municipal powers requiring particular housing tenure. So I saw that reference, which made me question whether you could do tenure. But when I read the seasonal communities brief, it talks about how once a town has adopted a seasonal communities bylaw, that you can implement what do they call it? Year-round restrictions. So can you give me some clarity whether, and I don't know whether when the
Sure.
seasonal communities was passed, whether it started out with notwithstanding any other general law to the contrary, and this supersedes that court decision, so, because this comes up a lot, if you
Yep.
could just illuminate us.
So I haven't seen the document you've got there, Mary, but I'm assuming the case that they're referring to is CHR General versus the City of Newton, because that's usually the case that gets thrown around about zoning regulates the use of land, zoning does not regulate who uses the land or who owns the land.
Yep.
And that CHR General case was essentially Newton had adopted an ordinance that prohibited the conversion of apartments to condos. And that was what was struck down there, was that, the court said what you really regulate through zoning is a multifamily use. Whether the multifamily use is occupied by a bunch of tenants with leases or occupied by a bunch of owners with mortgages and deeds is irrelevant. That's how the land is being used. So you're absolutely right to kind of focus on this, Mary, because this issue came back up when the ADU statute and then the regulations came out, because there were some people out there, and I will say lawyers that have good reputations out there, who were doing webinars and basically saying things such as, I remember people asking, well, could ADUs be converted to condos? And some reputable attorneys out there said, absolutely, because zoning does not regulate ownership. We actually pushed back pretty hard against that, including conversations with the Attorney General's office and the Executive Office of Housing Livable Communities, because we said an accessory dwelling unit, by definition, and as its name implies, it is accessory, meaning it has to be customary and incidental to some sort of principal use. So if you suddenly say that the principal, let's say, single family home is now going to be on a separate lot or in separate ownership from the accessory dwelling unit, you're no longer saying that that accessory dwelling unit is accessory to that principal dwelling. So the Attorney General's office ultimately relented and agreed with us that we were right, that so in some of the decisions that have been coming out since a lot of communities have been adopting their ADU bylaws, there was a lot of language like earlier bylaws were saying they must remain in the same ownership. And some were saying, well, they must remain on the same lot as the principal dwelling, things of that nature. And the Attorney General has been approving those. Even though there's, an element out there saying that zoning doesn't regulate ownership. It's like, we're not regulating ownership. We're just saying that these two have to be still held in common ownership. So now you introduce seasonal communities and this whole idea that, year round, as they defined, it has to be at least 10 months out of the year. By virtue of it being state law, saying that, seasonal communities will apply to designated communities or those who seek the designation, and that you can, in fact, limit occupancy to be 10 months per year. We've been given permission from the legislature that, to your point, Mary, it's like, notwithstanding case law that otherwise talks about how, well, we can't normally get into these items, the legislature is giving us the ability to do it, because I think this is the legislature's final understanding that if we don't have an ability to restrict a use of a dwelling to year-round housing, then they're all going to be short-term rentals, because that's where the money is, right?
Mhm.
So this is the license to be able to restrict them based on that, based on having to at least occupy them or rent them for a period of at least 10 months out of the year.
And
So yes, this is the exception to the general rule.
Because we're a seasonal community, as we look at any of our zoning regulations, we would theoretically have the legal ability to put that restriction in. It goes
Yes.
beyond ADUs and tiny houses. It could be
Yes,
any developments, because we've been putting language in that says it can't be less than 90 days. But we've been avoiding it must be year round because of what we thought was the rules.
Well, if I want to back up, just,
Okay.
oh, sorry, did someone else want to go?
No, go ahead,
Go
Karen.
ahead.
Okay, I want to just back up though, that could this apply to ADUs? Because this was something that we posed that question to the Attorney General's office before your town meeting. We sent your ADU bylaw in to the AG's office and asked them, would you comment on this? And would you tell us whether the bylaw is presented would in fact pass muster and approval? And one of the things that the Attorney General's office said to me, and I passed this along to Paul, was they discouraged us from conflating seasonal communities and ADUs. And the reason being that in their mind, the 900 square foot maximum ADU is, a protected use. Like they're even calling it, a Dover Amendment protected use. We cannot prohibit them in any way, shape, or form. Then there's the separate section of the statute that talks about seasonal communities and this whole idea of tiny houses allowing undersized lots to be developed, and that we can acquire year-round housing restrictions, and we can also grant residential tax exemptions for folks who are using them as year-round residences. So I am still curious to see what the Attorney General's office does with Eastham's ADU bylaw. Because I do remember, Paul, you and I spoke, and Marianne, forgive me, I don't remember whether you were part of that call or not, where we said, if there are things that are important to Eastham, keep it in the bylaw. Keep it in there. Let town meeting vote on it. Let the Attorney General strike it if they feel that it's inconsistent with the ADU statute itself. And that's what we're seeing come back from them on other ADU bylaws, that, if they felt that a community put some language in there that somehow is inconsistent with the regulations that finally came out, they'll just strike that language. So I know we do have in the ADU bylaw, some some language about year-round, 10-month rental, that sort of thing. Remains to be seen whether that's going to pass at the AG level.
Just as an FYI, the ADU bylaw, which we passed 2 town meetings ago,
At least,
2.
No, last year.
Was
The
it?
original one we passed several years ago.
Oh,
that
we did amendments,
Then we did the.
but we have not received approval from the Attorney General yet. And they
No, they asked for an extension
They-
because they're reviewing so many of them, I assume.
Okay.
So I'm hoping this month, November. But yeah, we decided to put that language in the bylaw. So we directly reference seasonal communities as our rationale for trying to get these other items. So we specifically say they cannot be short-term rentals, and then we specifically say that they have to be rented for 10 month, I don't know this 10-month thing, but year-round equals 10 months, but we specifically reference that. And then we specifically reference that they have to be actively rented. This gets to the other part of the tenancy, that they have to be actively rented. Which means they can't just sit vacant. Yeah, it's a year round, it's not a short-term rental, but no one's using it, and except for when my girl kids come and they stay in them, you know, it has to be actively rented. There's some language in there about you can have a 1-year thing if you gotta take it offline to do repairs or change its hands and the property's in limbo, all that kind of stuff. But basically, where we wanna be is you build an ADU. You sign a piece of paper saying it's gonna be actively rented, and we're going to be looking to see that that ADU is on the Board of Health's annual rental registration. Cause if it's not, then we're gonna, gets back to another thing about the enforcement. And we gotta call you and say, it's not on the list, what are you doing? You don't want it to be an ADU anymore, okay? Tell us how you're gonna decommission it, pull the permits to take out the kitchen, do whatever you need to do to make it safe. Or I gotta do repairs, so it's all that, so get back, this comes back to enforcement also. So waiting for the AG, hopefully they approve all these things, but we don't know. So we took a gamble that this was important for us, for the community, we put it in there. Waiting to hear.
What about the occupancy? What about the activity? It can't be not rented, Carolyn. Is that been touched upon by the Attorney General at all? Not only
The
just saying
activity-
you must rent it, but yeah.
Most of what I'm just seeing is what the ADU statute allowed, which was that you could prohibit ADUs from being used as short-term rentals. So most communities have incorporated that into their bylaws. I haven't seen any other community talk about year-round rentals yet. And we've been monitoring their approvals or partial approvals of these bylaws and kind of keeping track of what they're approving, what they're not approving. And I haven't seen anything yet about like a rental restriction come through yet. And I also wouldn't read anything into the fact that the Attorney General asked for an extension. They lost Margaret Hurley, if that name means anything to folks. She was the head of the municipal law unit at the Attorney General's office who reviews all of these. They lost her. She went over to the Executive Office of Housing Livable Communities to become like their housing expert under ADUs, seasonal communities, you name it. So they've had to hire another person to backfill, and they're just behind. So I wouldn't necessarily say that the fact that, they have requested an extension on East Ham's ADU bylaw, I'd say that's pretty much exactly what we're experiencing across the board from them this whole round. So we'll see when the extension is up. And also typically, I will also say this, usually the Attorney General's office, when they're finally reviewing a bylaw and they have some concerns or questions, or if they think that they might strike some language, they usually reach out to us before they issue the decision. And they usually have a conversation with us about saying, look, I've got a real problem with with East Ham's year-round language. And I can tell them exactly what the intent is and where that came from and how we think it's consistent with seasonal communities, et cetera. No one from the Attorney General's office has contacted me yet on any of East Ham's zoning amendments. But certainly if I hear from them, I will pass that along for whatever insight that might give us.
So just for purposes of our work, if we hear from them and there's a disagreement, we may have to amend the ADU bylaw again, correct? I mean, that could be one possible outcome.
That is a possible outcome, yep.
What we've passed is in violation, okay. From a,
The other part, though, I think if this all passes muster, what the seasonal communities regulations talk about is now the ability to get a year-round housing occupancy restriction, which I think this would
yeah,
reinforce everything, but I think that also might need a slight change for the good in the bylaws. That right now we have language that says you basically sign an affidavit attesting that this is going to be. I would rather
Have
put this to say this is a restriction. It's something that can get filed at the registry of deeds. It's more
Covenant.
yeah.
So that would be something I would want to do.
I just have one other tiny question about the seasonal communities. There's, I'm trying to get a sense of, it says seasonal communities must adopt the tiny home provision in a certain time frame.
Right.
When is that clock running for us? Do you know?
So we've only got draft regulations out, and I know Abby probably has the date at her fingertips about that. But we have to wait until the regulations are final. And then I believe we have 18 months after final regulations to adopt zoning. She is smiling and nodding at me.
It's after regulations.
I've seen 18 months.
I've seen 18
Yes.
months. Effective date, but it says 18 months from the effective date of 760 CMR.
Right. And that 760 CMR, those are the seasonal communities draft regulations.
Yeah,
So those have to be,
those are the
yeah,
regs.
those have to
Okay.
be final regulations and then add your
Okay.
18 months.
So if something comes out the middle of this winter, it could theoretically take us till 2027 before we get on the docket, potentially. Okay,
Paul, is this the official language? Is there, the one that you sent out, the bylaw?
Draft regulations.
yeah.
Is there a typo in 523?
I thought I saw one.
7?
I thought I saw that one too. 2 words?
Yeah, shall not be not larger than.
If it is, that's for the states.
State. Yeah, this was a state document.
And make sure that's fixed before, I'm sure the AG will find it. Fix it.
Maybe.
No.
Were there any other?
Yeah, so
ADUs shall not be not larger, so that requires them to be larger than half the gross floor area.
Is their definition of floor area the same as ours?
so that's, there's 2 other questions I wanted to work with Carol. So the seasonal communities regulations has a set of definitions in it for various things. I'm wondering whether we need to adopt those. I don't guess, why are they giving us those definitions? And we need to adopt them into our local bylaw. One thing that jumped out at me is the floor area definition.
Yeah.
We have different floor area definitions for different things in the bylaw, so by virtue of now we're a seasonal community, we need to get that in the definition and start adhering to that. And are these just kind of pick and choose a la carte as we need them, or you kind of have to get them all in the bylaw and start using them? And I guess we would have time to work through it, given the 18-month thing, but I didn't understand.
One thing that we could do, and I agree with you, Paul, because floor area, there's how you might define it in the bylaw, there's how it might be in the seasonal communities. And then, as I recall, in the final ADU regulations, gross floor area is a little bit different, and it's just like, you want to just shake the state and say, can you just give us one definition, please? And then I'm sure the building code says something a little bit different as well. So I do think we'll have to see what the final regulations ultimately say. I don't think we necessarily have to incorporate word for word every one of these definitions. We could just, as we adopt our seasonal communities bylaw, we could say, just reference 760 CMR 76 to just say that whatever words shall have the following meanings as they are defined in 760 CMR, if that's, easier. Because one of the concerns I have is that we adopt this text as it is, and then the regulation changes.
Yeah.
And now our bylaw is not consistent. Now we've got to go back to town meeting, so.
Then, you have a second question?
The other thing has, switching gears a little bit, so this group was contemplating the Cape Cod Commission has the model bylaw for, converting single family to multifamily. And we were wrestling with whether we wanted to take that on, but where we left off was it might be nice if we wanted to do maybe like, almost like a pilot test of the zoning. Because we see where applying this across the town, there may be a lot of variables and unintended consequences, but we thought this might be viable as a starting point to say, can we do this and have it only apply to historic structures within a certain area of town? Because those are the types of structures, big antique home that it's too big for anybody, but if someone wanted to convert it interior to a bunch of apartments or condos, the outside, it looks great. We're getting the density without any change to the look and feel of the community character. So as a way to maybe pilot this zoning bylaw, but limit it to certain types of structures and or certain areas. And my question was, can we do that, or is that getting into like a spot zoning or something that may not be legally viable? And really, we're talking about even maybe not, just antique, houses over 75 plus years located along Route 6. Because we have a bunch of those, and that could work well just as a starting point.
Okay. So I did have a concern that, yes, there can always be a spot zoning challenge. But that ultimately would have to be for somebody to bring that to court and for a judge to decide. I think more importantly, we might have a uniformity issue in that zoning bylaws are supposed to apply uniformly throughout a zoning district. So I thought of two things. The first was, you said you want to sort of do this on a test basis. You could consider a bylaw that kind of like a rate of development bylaw, where we're only going to allow so many of these permits to be issued over a certain period of time. That may not get you the desired result, however. If you really want to target, say, historic structures on Route 6, what I would suggest is maybe creating an overlay or a sub-district that just identifies from, Route 6 from this parcel number through that parcel number. We kind of create the corridor where we could allow conversion of existing structures and uses to multifamily.
Could we do that and for the area but then also limit it to homes of a certain age, or it would just really have to be open to everything along that overlay, regardless of age or?
Well, Well, let me ask, I understand that older houses tend to be bigger and therefore might lend themselves better to being a multifamily. But what if you've got, a modest size house on a decent sized lot? Why wouldn't we allow that, say, single family house that's got plenty of extra land? Why wouldn't we allow them to convert to multifamily if we want to encourage multifamily like along Route 6?
Well, I think that's where we hadn't resolved that question. So we were trying to just think of a way that we could implement the bylaw in the most innocuous way, just because I think there is just universal acceptance for the town. We would assume that we all want to see these, we'd like to see these historic homes refurbished. I mean, it kind of opens up some doors of like funding sources through CPA to make it more viable, and then also just, again, reviving these buildings that lend themselves to higher density without affecting the character, and then we can kind of punt on the different types of architecture and what that leads into until we got our arms around it. That was my notion of that we would eventually be able to grow into the rest of building types and areas, but this was just a very targeted intro to it.
Carolyn, if there was a larger effort around historic preservation in the town, a larger sort of task force, whole inventory plan, could you target historic houses in a much larger plan? Or are we still getting into the uniformity issue here? It's
Well, I think you could do that. And even, as Paul alluded to, using CPC funds for restoration renovations. I think both could be done, but I don't think you need to amend your zoning bylaw to promote it. So if we allowed something, let's take CPC first of all. If you were an historic home, you probably qualify for community preservation funds to begin with. If you're going to create community housing as that's defined under the Community Preservation Act, then you may also qualify for funding to restore that property or to convert it. The question really becomes, is the multifamily use allowed where that historic structure is located? And I'm going to guess that for the most part along Route 6, maybe there's some areas you're looking to target that I'm not thinking of, but for the most part, I would think that multifamily would be allowed. And do you want to just make not at all?
no,
Only in the
Nope.
ECS.
Okay, well, that's one way to switch the lever.
Yeah, that's why we were trying to figure out, because it's all basically residential, so you can do single family or duplex. And we're trying to differentiate this from, obviously, the duplex. This would be converting a single family home to, 3 or more units, so it's multifamily. That's not allowed anywhere outside the ECS.
Mm-hmm. Okay.
Yeah.
Well,
I'm wondering-
what if instead? Oh, sorry, go ahead.
Oh, my question was how many properties are we really gonna be affecting here if it's only the 3 or more? We're already allowed, if you have a farmhouse on Route 6 and you want to divide it into 2 condos, you can do that now.
Can you do that?
If you were gonna, you could separate them into
Turn it into a
duplex.
Duplex, yeah,
That's what I meant, yeah.
Two separate.
So we're really only talking about the ability to create 3 or more units.
Yeah. And this gets back to the duplex allowance for lots 30,000 square feet and over. I think we did this the first year. I think we did that 4.5 years ago. And it goes to, we haven't done any education, like no one has taken advantage of that. I find it unusual that, that someone with a large lot that might not have come up, like I'm gonna build a two-family because mom's gonna live on one side and I'm gonna live on the other. Yeah, yeah, I just, so I don't know whether we have not educated people that that is an option in town. And I don't know,
No, that's a good point, that
Yeah.
we've done that.
we did that years ago and not a single one person has taken us up on that. We thought that would be a first step into, especially in the ocean side of town that has primarily 1 acre lots. We thought this could be a no-brainer for someone that wanted an extended family. I mean, it's more than the ADU because you could actually have built something
When you
was-
find an extended family, just as an investment.
as an
Buy the
investment, yeah,
house, instead of moving out of your house, you can cut it in half.
cut in half
as
and,
your- as your-
and you,
as your
and somebody else
age
is paying your
increase.
mortgage, yeah. Which is,
So I think
So,
so anyways, we
it
should,
sounds like targeting it to the historic would be difficult. We could do an overlay within a fine area. But it would really need to be open to any property.
You
I
could
mean,
also-
Sorry, go on.
I was gonna say, you could also consider similar to like what we did with the cottage colonies, converting them to hotel motel uses, whatever. We could craft a new use that would allow a conversion of existing residential uses. And again, decide what zoning districts you want to allow that in, or do you only want to create a limited district where it's just, say, a Route 6 corridor to begin with. But you could allow conversion of could be an existing residential use to multifamily. It could be a conversion of any existing use to multifamily. If you want to be broader like that, maybe you don't. You could also put a requirement in there that there has to be some sort of like minimum lot size so that, the modest single family house that's, sitting on a 7,000 square foot lot may not lend itself. It may not be appropriate for multifamily, but a modest house on a larger lot might.
right, I think, I forget, Paul, in the Cape Cod Commission model bylaw. Is there a lot size restriction for single to multifamily?
No,
no,
I didn't think so.
but a lot of that, like many other things, that's also gonna be driven by the lot size for the septic capacity.
Right, right. But I think to Carolyn's point that maybe the thing that we would be concerned about single to multifamily has to do with abutters and noise and parking and, if it's a small lot, you suddenly have 2 or 3 times the number of people living there. What does that do to the abutters? And so putting a lot size limitation or restriction on it kind of mitigates that a little bit. I think enough for it to try it.
Yeah, I mean, I think we'd also could make it contingent to all the site coverage issues, so
Right,
sometimes in order to do the conversion, you may need to add on something for just code, compliance, egress, whatever, or just you want some more, so again, that's limited, you need the lot size, the septic, and the site coverage if you're trying to do an expansion. So
Right.
there are some things that would limit the pool of how would be eligible. So-
Right. But the historic, trying to target the older historic larger homes, those are mostly around Route 6, but they're not all there.
Correct.
So maybe it's a combination of those two things somehow.
okay,
that's-
we're sort of running out of time right now. Paul, did you have anything else for legal questions? Anyone else while we have Carolyn? I really thank you, Carolyn, for this.
And
You're welcome.
Abby, we will be back to you. multiple times before.
I know you will.
Before we get out the
I look
door.
forward to the next round, everyone.
Yes.
Thank you.
Thank you very much.
All right.
Okay, appreciate
Thanks,
it.
everyone. Have a good day.
Thank you.
Cheers.
An item I've had on the agenda a couple weeks in a row, and we get 15 minutes, and I really feel like I want to bring it up. I've been meeting with Paul. In between these meetings, we need to go over where do we stand, where's the work, what's the agenda for next meeting, that type of thing. And it's just becoming really clear to me that this list is, we need to sort of get real about this list because we're kind of running out of time. Paul and Jackie have, and Basil have, have some serious capacity issues, not only in their day-to-day work, but also all of the special projects which they have in addition to zoning, such as housing and town center and a variety of other things. So I wanted just to look at our list because I want to throw this up and hopefully we can discuss it and maybe the next time we can resolve it. Inclusionary zoning, we have a consultant. We getting a
Yes, they're gonna
consultant?
be working on that
Yeah.
and that. Scheduling that for December. Whatever, 16th, the 19th.
On our schedule,
Yeah, they said they would be able to have.
December 16th, we've got
Draft.
Carolyn Motors.
Yes.
include
Yeah, I
that.
got it. So we might have to
Sure.
make some adjustments.
That's fine. So, and we've got sort of technical analysis happening there. I'm just gonna jump ahead of a couple of things. The site coverage averages. We've been invited, the planning board is still on the 19th. Are they still gonna do that discussion?
Yeah, so I wanted to talk about that for a second. We're,
Okay, let me go over
Sure.
this and then we're gonna come back to that 19th. So we have sort of a plan. The motel cottage colony, again, we might be able to, this whole issue of year-round tenancy was the legal question we had there. The zoning enforcement position, we've got that sort of on a timeline. Jackie has done a lot of work on fences and campers, and so I think we're well underway there.
Yeah.
Sign code is one.
I have a draft.
You've got some drafts. You've got drafts of definitions too.
Yes.
Okay, so those are the ones. And that's still a lot of work. I want to raise. There's two issues here. One was the single to multifamily conversion, and the other one was District E, the commercial district. Paul and I spent some time, and I spent some time looking at maps. And not only did I get sort of like, this is too much to think we're going to get this done between now and January, but I actually, looking at District D, I was like, well, could we just get District D in, could we get the windmill and a few things into District D and have that at least a basis and come back next year? And it actually, in looking at the land use, there is enormous amount of opportunities and thinking that we should do around this whole center here. There's a lot of undeveloped land. There's other plans such as complete streets plan that has not gotten off the ground in terms of funding, but has huge potential. And so I came away from that thinking, this is sort of like a mini DCPC, this District D. Like, we should be thoughtfully thinking about the land, the uses, the programs, and what we need to do. Similarly, it overlaps with the multifamily in the sense that there is a lot of opportunity here with some of the multifamily, and it just hit me. We have to do a lot of land use. We're sitting here saying, well, can we exclude this? Can we exclude that? I'm looking at, this is right from the Cape Cod Commission. Our small lots and our extra small lots represent 81% of the lots in town. So when we start talking about conversion, and when you got 81% of the town in tiny lots, I think thinking through all the issues of, well, are we good, if we've got to maintain site,
I want to interrupt you.
Coverage.
What do you mean by tiny lots? You said 87% of the lots are tiny lots?
they're called small or extremely small.
Well,
They define.
that's not what the data shows. So we have 3,636 between a half acre and 3/4 of an acre. So someone's definition of small
I don't think
I'm
that
looking at the analysis here that was provided earlier. You know,
by who,
by the town, the lot size analysis for the entire town.
where did that come from? Because that
That's
was,
the map, worked on a few years.
That's the map, but this was the whole thing that we're basing. Non-conforming, so they might be non-conforming, but you're mixing the idea that they're not acre. The idea that it's non-conforming doesn't mean it's a tiny lot.
no, I don't think that's correct.
This is the data that we've all been basing our meetings on.
Is that, we didn't do that, Matt.
That's our map.
That's our map?
Yeah, so I agree with you that there's a lot of lots that are non-conforming, but conforming is 40,000 square feet, which is a very big rate. You know,
I'm looking at Jim Kilverhan's listing, that his listing was consistent with the Cape Cod Commission.
I don't agree.
How-
I
how
don't
they
agree
define
that
small?
I don't agree that the town is full of tiny lots. That's what you just said.
20,000 and under. 20,000 square feet and under.
No, that's even at that, it's only 600. It's 491 plus 278, so it's
Why don't we do
So-
this?
700 something.
Let's clarify, this is a huge day.
I know it is, because it's 3,000,
No, we've,
it's 3,700
I-
lots of
I've
greater than half
written
an acre.
reports that say 80% of our lots are smaller than 20,000 based on Jim Kilverhan's dissection of the assessing map. So how are we,
This is the assessing map from March of 2022, and those are the numbers, so you're going on wrong information, I think.
well, I mean, I got Cape Cod Commission here and I had Kilverhan there, so I don't know.
Well,
This is provided by the town.
but the point is doing this, we don't have enough time to do this.
Oh, yeah, getting back to that
I mean,
point, yes, I just don't want the narrative
so-
that we have all these tiny lots.
Well, my concern is we don't have time to do what I think is thoughtful land use analysis. I mean, we really need to think.
Well, you're only talking about 3 more scheduled meetings between now and
Yeah.
middle of December.
Yeah, I know.
And then you get holidays and all that, so it's, yeah.
Yeah.
we can't do
So
it.
now, as opposed to just kicking this can down the road, there's a second part of my concept of if this gets deferred. I don't think we should take this off the table. Now, one of the things when we defer historically is we get to March, they approve things to go on the warrant. We sort of monitor the public process in April. We do a quick meeting in May, and then we take the summer off. And I think between District D and this issue here, and potentially any other things, I would like to say that maybe we, once the warrant is in April and May of next year, we actually work on some of these issues insofar as we scope out what is the information we need to know to make some decisions. I mean, we kind of really scope out in the spring so that Paul and Jackie, and whether we get consultants or we have Cape Cod Commission, people can actually be assembling information, so we're not starting from scratch come late August.
Because there
or
really is
September.
such a short window.
It's too short of a
September to
window.
December.
It's how the DCPC got kicked into 2 years because we couldn't do it. And so I'm just framing, I feel like we're at one of those junctures and blindly we can go forward, but I just don't think we're gonna
No, I think
get
it's something to
done.
consider. I mean, it doesn't mean we have to meet every 2 weeks throughout the summer, because I'm sure that wouldn't work. But a couple of meetings, whatever, in May, early June, whatever,
June.
to at least set a tone for it, so we know we're getting into
Yes.
late August or whatever, we jump back into it. We've already got a plan.
Yeah, we've had the work scoped out a lot more, maybe some of the legal analysis finished. I mean, this is coming out of my conversations with you. I mean, jump in if you.
No, I agree. It's just more, like I say, I turn my brain off after the town meeting for a while. And we don't get back to zoning until the end of the summer. So this would just really be keeping it keeping the pot simmering and continuing to work for it and then work on it kind of throughout the duration, but then we can ramp up quickly when we need to.
Especially if we're looking for outside help. I mean, the way it is now, we decide in September, hey, we need this help. Let's get this consultant. Gotta schedule them. It's October, early November before we hear from
Yeah,
them.
we
We
should
make
be doing
quick
that.
decisions.
Right.
We can, if that understanding what we need is in May, early June, the consultants can be hired and, their information,
Maybe
take the summer to get this stuff together so we can hit the ground running. in
Yes, we
September.
did work. Yeah. No, I know.
Can scope this out for a town meeting 2027, but keep actively working on it.
And actually, I have to say, the whole District E thing, when you start really looking at maps and starting to think about all of the analysis we did with DCPC, it could be as exciting. I'm not saying it's a huge built out thing, but it's just a special place. And I think how, this is another nexus for the town. And to think of it comprehensively, as we did with Town Center. I mean, we only proposed the zoning, but we illustrated a lot of things like these roadways, these sidewalks, all of these other things could bring us together. I think that kind of a planning effort could happen here. And I think it could be a big deal. I mean, I'm more, it's not just kicking it down the road. It's like, oh God, if we did this, I really want to do this right. Like,
Mhm.
this is a very significant part of this town. So any thoughts? That's
Yeah.
my thinking.
I think we're in agreement.
Okay. So we can sort of retool some of this work plan then based on that. You and I can just dig down on that. Okay. Any other matters that we should be discussing before?
Well, Paul, did you have something?
Oh, yes, you had
Yeah,
something. I'm
so-
sorry.
We were planning to have a work session with the planning board on November 19th. I was hoping that we could start that and then that the task force could attend that, or at least whoever's available. And really just be able to talk about site plan review. We're talking about some adjustments with the site coverage data, adding some things in here, but just feedback from the planning board itself. I think it would be beneficial to just have a broader discussion about site plan review in general. What's from the board's perspective, what's working, what's not. Does some mechanical adjustments make sense, or do we need to like step back? And we got into this ourselves last time too, like
Sure.
we need to step back from this again and look at it. So this was kind of a way to get the conversation going. I thought we could have that discussion on November 19th, which is the planning board's regular meeting date, but start at 4, so 4 to 5 have this session. We're trying to just do logistics with availability. Michelle Violin, who's the vice chair, and she's also on the strategic planning committee. I don't think she's gonna be able to make it. She's gonna be remote, but I'm not sure she'll be able to make it. I think that I want to make sure that she has an opportunity to be involved with that. So we're just trying to figure out if 4 o'clock's gonna work. If not, then perhaps we want to reschedule that.
Well, do we have to wait?
Yeah.
I mean, we're gonna run out of time, so can we get an off? I mean, the concept was, they have everything we've talked about, the criteria they have in site plan review. So the question is, how are they approaching that criteria? And the feedback is they haven't been, well, the feedback is they haven't been necessarily shaping the projects.
Well, I get, yeah, I mean, Kevin wants to say.
I guess I think the sense is among a few folks that, yes, they have been shaping the projects. The question comes down to how you define them.
Yeah.
That's my thought.
Okay.
That to me, and maybe it's their interpretation, their habit, or limitations on what they think they can do. Shaping a project is looking at landscaping. Shaping a project is the shape of the driveway, so they drive out instead of backing out. All important stuff. I'm not knocking it at all, but there's been some about, lighting comes up time to time. There's different things, but I'm not sure if everyone would agree that the project's been shaped
Okay.
too dramatically. Maybe I'm reaching for the stars on a couple of the projects, but I think it's I'd like to see a general understanding by everyone as to what shaping a project really means. We can't just tell people flat out, no, we can't do that. But there have been a couple of projects that have come along that have had, I thought, a list of issues. And in the end, there was a couple of things that they were required to do and they agreed to, but just me felt that we got away with a lot on that one. But again, maybe I've got a too harsh a view as to what that really means. shaping the project, but that's.
So are you asking us if we want to change the date of, because I don't know that I even have that on my schedule. A joint meeting?
No,
Yeah,
this was,
still
this was
time
just
to
to attend their
Okay.
meeting. They were gonna do, they were going to do a discussion on
Okay.
site plan review. And we thought it would be very helpful for us to be there to engage them in that discussion and understand, you know, I mean, it's being presented historically as a legal issue. They can't do certain things, but I mean, I had the Dedham Planning Board say to me, yeah, I like your building, 10%. Here's your condition. Just reduce it by 10%.
That's, and I think that's
And-
where I get it from
And I
too.
went, okay, I
Not
have
Dedham, but-
10%.
Yeah, then when I
Yeah.
was on the Framingham CBA, I was an alternate, but, and it's different than planning board, but I had to sit on some planning board meetings too on things that affected my own neighborhood, stuff like that, and it, iron fist. No one questioned the planning board. I mean, you got mad at them, but when they said something, that's what you had to go with.
Yeah.
And I don't know if they were getting away with murder when they did that or what, but it seems that they really ruled the roost. It was an iron fist that they
Mhm.
spent the time anyway. And that's what I expected to some extent. And I don't quite see that here. I haven't experienced any particular
Mhm.
projects that have really been beat on terribly. Some have been shaped, no question, but yeah, I think there's probably a wide range there. Now, I don't know legally if some of that's been trimmed back. You know, some people complain about it,
Yeah.
and I don't know, but
I think,
that was my
I
experience.
agree with Kev. I think it's just, part of the discussion is just getting it all out on the table, like what does site plan review mean to everybody as a board, and then trying to find a consensus about what is. But, you know, here's what everyone thinks it is, but here's what it needs to be, so that the board can function appropriately and in need with the bylaw. And I mentioned this too, it might be a combination of adjustments to the language, it might be an adjustment to how we actually run the meetings, how we do staff reports. You know, I think a lot of times the things that get scrutinized are the things that an abutter raises, or if someone on the planning board has a particular issue that we don't necessarily go through everything we don't treat every single thing on the criteria equally. You know, it's just we respond to the big issue. And sometimes so, and that might be, like I said, the way we actually go through, maybe more means we have to have longer meetings and more intense meetings and go through it more structurally, but again, you know, for the board to be able to get this all out, see where we agree, where we disagree, where we need to like get on a new baseline of understanding what site plan review is. And I think that's gonna inform work that this group needs to do with it.
I mean, I would certainly appreciate, just on a personal level, to hear it or hear it again, kind of thing. And I think that I sometimes feel the planning board should have a few more teeth, again, from past experience. And some of the attorneys that come before us, they're almost every month or every other month, and they know strengths and weaknesses of the whole system, and then we use them to their client's benefit. And that's what they're paid for. But criticizing is just what it is. But you know, from the town's perspective, if we're trying to have some control over what's going on here, shaping things to keep with what the general community wants to maintain, and that is maintain what they know as Eastham, with some improvements, but not lose the total character. I just worry that at some point down the road, we look back 20 years and say, geez, you know, look what's happened over 20 years. It all slid to hell. And I don't want that. I don't think anyone wants that, but it's generally not done with one big swipe of the feet, and no one notices it.
We have new board members too.
Yeah.
New board members, so.
So we're running 5 minutes over and I'll go.
I should
I'm sorry, you
just,
have-
one last point, I've been watching the new podcasts. That would be a great opportunity to talk about some of the zoning changes.
Yeah.
So,
Yeah.
podcast about zoning.
Yeah, that would be good.
If we could put Paul on stage.
They already got a target on it.
Okay. Well,
Remember, that is one thing.
And housing too, they don't, do you have one scheduled for housing?
These, all the topics are going to be happening. I don't know what the schedule is going to be.
Just as a touch back on when we're talking about shipping containers and sheds
Mhm.
last week, we thought we were ready to start drafting. Did we do an exemption for Holmes Road in the industrial area? For that?
Yeah, we mentioned that.
Yeah.
We did mention that last
Yeah,
week.
yeah.
And what about an exemption for if it's not visible from a public roadway? 'Cause I'm thinking, if I got 6 acres and I'm way in the middle of the woods, do I really care whether there's a container there or not? Or do I just care if I can see it from a roadway?
I think that's a bigger conversation we should have.
I know, I just want to see. if
I
we-
don't think we had.
We didn't have it in there, but I think we should,
We left it that, right now it was that you cannot use a shipping container for storage in anywhere except for in the industrial area. But the subset of that is if you are operating a service trade in a residential, you could, so long as it's not visible from the street, screening it through fencing or otherwise. That's already on the book, so
Okay,
that's kind of where we.
thank you, Carolyn, for 2 minutes one more time. We're 5, 6 minutes over. Our next meeting is in 2 weeks. We are meeting on
8.
the November 18th. And
That's 1 to 3. They had
is that 1, 2, 3?
Yeah.
Yeah, I think somebody had something going on, so they didn't adjust it. What?
November 18th, 1 to 3. Okay. Can I get a motion to adjourn?
So moved.
Second?
I'll second that.
All in favor? Aye.
All right.
Thank you very much, everyone.